You want to hear about the Manafort trial today a little bit? Yes, I thought so. Well, it got underway around 1:30, 1:45 today. And this is as reported by, I think it's Reuters. Paul Manafort's trial resumed shortly after 1:15 today, Eastern, with Judge T.S. Ellis III saying the jury would hear from one of the last prosecution witnesses before he addressed motions from both sides. One of those motions includes a sealed filing Manafort's defense submitted today. Prosecutor Greg Andress, you remember he's the one who was crying, said the government has responded under seal. There was no indication in open court about the content of the motions. After a brief sidebar, Jim Brennan, an employee of the Federal Savings Bank, took the stand. Brennan, who received immunity for his lots of people getting immunity here. What would you like me to sing? You get immunity. Any Broadway songs you would like? Yes. How about Hello, Dolly? Kind of the same thing. He's a vice president with the bank from which prosecutors say Manafort fraudulently secured $16 million in loans. Why do they need to give anybody immunity in this case? Seriously. Why give anybody immunity? Why pick Manafort as the target? Why not pick the vice president of this bank? Well, we know the answers to these things. Jim Brennan, this vice president for Federal Savings Bank who got immunity. And by the way, if I were defense counsel, I would add up the number of witnesses who either got immunity or pled to lower included offenses. And I would give that information, and I'd have a whole chart of it for the jury. See this guy testified? He got immunity. See this guy testified? He got immunity. See Gates here? He was up for 29 years in prison. He may get parole. Look at this one here. Probation, that is. Look at this one here, and just go through the list. That's their case. It's a manufactured case. I'm just saying if I were defense counsel. So this vice president, Jim Brennan, Federal Savings Bank, testified this afternoon that a statement the bank got from Paul Manafort in August 2016 claiming $4.4 million in income the previous year was inconsistent with other records. Several witnesses have testified that the firm actually made less than $400,000 in 2015. Ex-Manafort employee Rick Gates testified that he sent the authentic profit and loss statement to his boss as a Word document so it could be doctored. Such inconsistency, quote, would go to the character of the borrower, which should mean that we would raise a red flag, unquote, Brennan said, the guy who got immunity. You want to know who you're lending to and that the information they give you, you can rely on, said the guy who got immunity. On Friday, while questioning a former employee, defense attorneys suggested that Manafort put up enough collateral through real estate to guarantee the $16 million lent by the bank. Prosecutor Greg Andress, the guy who cried, tried to undercut the idea Monday, asking Brennan whether the Federal Savings Bank generally relies on real estate sales for repayment for loans. No, said Brennan, the guy who got immunity. We're not in the business to own real estate, he testified. We're in the business to get repaid. Brennan, who still works at the bank, the guy who got immunity, is the secretary for the credit committee that approves loans. He's testifying under an immunity order. Did I mention he got immunity? Which he said means I cannot be prosecuted unless I commit perjury. But you got immunity to avoid prosecution, pal. 2:30 p.m. John Brennan, Vice President, Federal Savings and Bank, who got immunity, also testified today that Paul Manafort didn't declare on his financial applications that he had mortgages on 2 properties in New York, information that would have made it harder for him to secure a loan. Manafort was approved for 1 loan with Federal Savings Bank, but rejected it at the signing table, Brennan testified. Manafort laid out new terms for the loan. The president of the bank, Javier Ubari, rejected the new proposed loan structure, but the loan closed anyway, Brennan said. It closed because Mr. Kalk wanted it to close. That's the CEO of the Federal Savings Bank. But the prosecutors have it all figured out, you see, because Kalk apparently wanted a cabinet-level position. So it was quid pro quo, don't you know? An email between bank employees presented Monday showed financial details Manafort provided to the bank were red flags and inconsistent, Brennan said. Manafort, now, I have a question. Just think about this logically. If it's the CEO who approved the loan because he wanted a job in the Trump administration, which he didn't get, then why give immunity to the vice president? Why would you give immunity to the vice president? Right? If it's the CEO that cut the deal. Manafort later told bank officials he let his friend borrow the credit card to purchase season tickets with the New York Yankees and had not yet been paid back. Manafort later indicated the friend was his business partner, Rick Gates. But on Friday, a Yankees executive said Gates had never purchased season tickets with the team. Wow. Well, I think that's a life sentence right there. Let's hear some more, shall we? Defense attorneys for Manafort are again trying to argue that their client either wasn't the one who filled out documents inaccurately when applying for loans or else did not know he had done anything wrong. Asking about a profit and loss statement showing Manafort's firm made $4.4 million in 2015, Richard Wessling asked Federal Savings Bank Vice President Jim Brennan if any one person must prepare such documents or whether there's anything wrong with updating such statements as necessary. Brennan agreed that anyone at the company could update such documents if needed, but multiple witnesses have testified that Manafort's firm made less than $400,000 in 2015 and that there was no reason to believe more money would be coming in when that document was sent to Federal Savings Bank in 2016. Wessling went on to suggest that the loan was hardly a favorable one, given that Manafort put up 2 properties as collateral. I've put up properties for loans. I don't have a lot of loans. You put up collateral. I don't even know why. Again, I'm not the same situation, but people put up property for loans. I mean, you got to show them your income. You've got to show them a number of things. Depends on the situation, but that isn't a prima facie case that you're stealing from somebody. I'm just pointing it out. Wessling went on to suggest that the loan was hardly a favorable one, given that Manafort put up 2 properties as collateral, a $12 million house in the Hamptons and a $2.7 million condo in Alexandria, as well as $615,000 cash. The interest rate was 7.25%. And Manafort had to pay a $285,000 fee. Now, if this was for 2016, and you're paying 7.25%, that's pretty high, isn't it, Mr. Producer? 7.25%. You got 2 homes as collateral. That add up to almost $15 million. You put up $615,000 cash. It just doesn't sound like a gimme to me, folks. I'm not a juror. I haven't heard the whole matter. During cross-examination of Federal Savings Bank Vice President Jim Brennan, who got immunity, defense attorney Richard Wessling raised the possibility that the bank may have been at fault for errors that affected Manafort's loans. The bank may have been at fault. Wessling pointed to an incorrect address Brennan had entered in one application and made mention of another error by another employee that made Mr. Manafort's income look better. Wessling also asked Brennan about a review of one Manafort loan conducted by a regulatory body called the Office of the Comptroller of the Currency. During a review of the bank's business, the bureau within the U.S. Department of Treasury had concerns about how the loan was analyzed, but didn't raise any red flags about information provided by Manafort. The point being, a federal agency already looked at this. Brennan testified that one of the loans received a rating of 4, the lowest possible rating an application could get before it could be ejected. Brennan said he would not have approved the loan and it would have gone on the bank's watch list, but he didn't have a choice to give the loan the bare minimum rating. When asked by the judge why he gave the loan a passing grade if he didn't deserve it, Brennan testified Caulk had pushed it. Everybody has a fall guy in this. Have you noticed that, Mr. Producer? Nobody wants to take responsibility for anything. But the very, very interesting part comes next. I have to take a break. The judge again spars with the prosecution. This is very, very compelling. We'll be right back.
Mark Levin.
Let us continue with today's Manafort case. Trial, Mueller's case, really. Late today, about 4:40 p.m. Eastern. Whether or not Paul Manafort's prosecutors are done with the case depends on how Judge T.S. Ellis III rules about whether an agent from the Treasury Department can retake the stand. Paul Ellis already testified that Manafort did not report foreign bank accounts on his taxes. Prosecutors wanted to come back and say his consulting firm didn't either. Well, defense attorney Thomas Zenley said that in closing arguments, they do plan to say Manafort had no obligation to report foreign bank accounts in the years he only owned 50% of his firm, Davis Manafort International. It's very clear that if you do not own more than 50% of the entity, you do not have a responsibility, Zenley said. Manafort's wife owns the other half of the company, and they filed joint tax returns. He's accused of failing to report the foreign bank accounts from 2011 to 2014 for 1 year, charged 2011 Manafort was the firm's sole owner. When Manafort filed as a foreign agent in 2017, prosecutor Uzo Aznyi noted he also described himself as owning 100% of the business. Judge Ellis pointed out that Davis Manafort Partners, later Davis Manafort International, was not accused. You could have indicted the company, but you didn't, he said. The assistant U.S. Attorney Aznyi said that was true, but it was the defense that was now making the argument that this was a corporate responsibility. Ellis took a short recess to decide the issue, predicting neither side would like his ruling. Well, they came back at 5 p.m. Eastern tonight. Judge T.S. Ellis III allowed prosecutors to call back Paula Liss, a special agent with the Treasury Department's Financial Enforcement Network. Special counsel confirmed that she would be their last witness. Prosecutors intend to ask her if Manafort's consulting firm ever reported foreign bank accounts. Ellis said he would instruct the jury that they cannot find Manafort guilty for his company's failures, but they can use the evidence to decide his willfulness in not reporting 32 overseas accounts on his personal tax returns. After Liss answers 3 questions from prosecutors and any cross-examination from the defense, Ellis said he will hear motions to acquit. That, by the way, is normal procedure. The special counsel's office, after a few minutes with that witness, called its final witness. And let's see. The special counsel's last witness, this Paula Liss, who works for Treasury, had testified early in the trial but was called back, as we pointed out. Liss left the stand after 5 questions. Your Honor, the government rests, Prosecutor Greg Andrus said. Afterward, defense attorneys in a procedural hearing asked that the charges against Manafort be dismissed, saying the evidence lacks materiality and a failure to show the necessary willfulness. Judge Ellis sealed the courtroom without ruling on the defendant's motion for acquittal or asking whether Manafort will present any evidence. What we do will not be permanently sealed, he told media and onlookers gathered in the courtroom. When the case is over, the seal will be lifted. Lead defense attorney Kevin Downing asked to have until tomorrow morning to put together his motion for acquittal, and Judge Ellis agreed. That's where we are today on the Manafort case. So what will happen is the judge will deal with motions unless he acquits right there and then. It'll be the defense turn, as we say, to put on their case. All you've heard so far is the prosecution and cross-examination. You've not heard anything really in terms of the defense counsel's case, so we'll see how that goes. Now, what is missing from this trial? Anybody? Collusion? Conspiracy to defraud in an election? That's a clever one. Not too many Russians in this trial that I can think of. I thought Manafort was the gateway to Trump. Well, they want him to be. They just want him to say something, anything, to take down Trump. Anything. But so far, nothing. Now, on that front, the Mueller front, and I should say affront to the Constitution, Rudy Giuliani was on Fox and Friends this morning, and he had an interesting tidbit here. Cut 1, go.
Should be a big week.
Should be. I hope so.
I think this is the week, I think.
All right. Really? For what?
I think he'll give us a decision this week on our counterproposal. We're coming down to his looking really bad by interfering in the election, and I think he's got to get it over with by the beginning or early September.
Well, I hope so, but that's not necessarily the case at all. Mueller doesn't play by the rules, neither does Rosenstein. So we shall see. And it's quite possible that a subpoena will issue, that Mueller will get a subpoena from a judge, or who knows. And then we're off to the races, into the courts. It's quite possible that Mueller will push this. You know, I've said it before, but when I was on with Hannity last week, I said that Robert Mueller is a greater danger to this country than Vladimir Putin when it comes to the campaign and comes to the Constitution and so forth. And so basically they cut it off, that I said, all the media, that Mueller is a greater danger to the country than Vladimir Putin. Now, I'm no fan of Vladimir Putin, as all of you know. I've never been a Code Pink Republican. But in terms of our constitutional order, forget about the military. In terms of our constitutional order, Vladimir Putin doesn't present any threat. He can't. What's he going to do? Again, forget about the military side of this. Yet Robert Mueller is prepared to take a shredding machine to our Constitution, just as Rosenstein has, just as these FBI guys like Stroke did. We'll get to him. There's nothing new to report on him, but we'll get to him. This is important to remember. The president has an obligation to over 60 million people who voted for him, for our electoral process, our Constitution, separation of powers, and the office of the presidency, to fight Mueller, to fight him. Now, I understand the Praetorian Guard media, which pretends it's under attack, that is the free press, has this all twisted in a knot, has it all turned upside down. The media in Wonderland has done that. That it's the president threatening the Constitution. He's not threatening the Constitution in the least. They want to overturn an election. They want to remove him from office. They want to disenfranchise over 60 million people. And they do not want anyone to get into the way of their agenda. The president has a responsibility to fight that, to fight them, and to fight efforts through one unelected, unaccountable prosecutor to reverse the Constitution, the election, by violating the Constitution. I'll be right back.